Hello, everybody. Today, we are going to be doing something a little bit different than what we normally do. We are going to walk through the Rick Cho trial. This is 3 days of trial. I will do my best to fast forward through anything like that's kind of stalling out the procedure, but we are going to be walking through this because this has been a case that has been in question for kind of a hot minute now. So, Court TV has all the proceedings on their YT. So, that is what we are going to be looking at. And let's hit it, everybody.
Available due to illness, so juror number 259 will now be a part of the panel. We understood on that, and we will join the. Oh, you're already down there. Okay, so Mr. Colbert already told. Thank you, Mr. Stevens. All right, ladies and gentlemen, we are about to begin the case of State versus Chow. Again, I want to thank you for your important responsibility of jury service. As I told you earlier, without folks like you willing to serve, our justice system simply cannot function. I want to introduce a few folks. You've already met Mr. Colbert. He's our chief bailiff. And any of the folks that with the yellow coat, they are sort of your eyes and ears this week. They're here to help you if you have any questions, any problems, any concerns. They'll get you to and from the jury room. If you need to address me with any issues, you would notify them. But again, they're here to help you. To my right is our court reporter, Captain Spires. Cat takes down everything we do in here. This is a court of record. Or in the event there were an appeal, everything she types up would go to an appellate court. If sometimes she tells somebody to speak up or say that again, she's not trying to point that out to your attention. She's just making sure she got it down. To my left is my law clerk, Becca Sternberg. She is my lawyer. She is a lawyer that assists me with my duties. And further to my left is Olivia Miller. She is a law student who is visiting with us for 2 weeks. So I just wanted to, if you were wondering why there were who folks were in the courtroom.
Judges is taking care of some procedural stuff.
Now, the instructions I'm going to give you now are an introduction to the trial. These remarks are not a charge on the law in the case. I'll instruct you on the law applicable at the end of the trial before you consider your verdict. This is merely an explanation of the procedure that we're going to follow during the trial to help you better understand what's happening. We're not going to be, and you're not taking notes during the trial. The defendant is charged by warrants and a separate indictment filed in this court with the crime of murder. The elements will be explained to you later. The warrants and the indictments are simply the charge by which this case is brought into court and is not in any sense evidence of any of the allegations it contains. The defendant has pled not guilty to the indictment. Therefore, the state has the burden of proving each of the elements of the crime beyond a reasonable doubt. And it's your duty, ladies and gentlemen, to decide whether the state has met that burden. Your purpose as jurors is to find and determine the facts. You are the sole judges of the facts. If at any time I make a comment regarding the facts, you must disregard it. You are to determine the facts from the testimony you hear and other evidence introduced during court. It's up to you to determine the inference which you feel may properly be drawn from the evidence. It's especially important that you perform your duty of determining the facts diligently and conscientiously, because ordinarily there is no way to correct an erroneous determination of facts by a jury. If I make an error of law, there are appellate courts in our state that will correct me, but they don't get to go into the jury room, so it's important that you are conscientious in your duty. Now, on the other hand, and with equal emphasis, the same rules that make you the judge of the facts make me the judge of the law. The law as given by the court is the only law you may consider. You must accept and follow it even though you may disagree with it. I can't tell you what the facts are, and you can't.
So I want to tell you why this is really important, right? So the judge is giving some sort of prefacing instructions to the jury before this actually kicks off. It's important what he pointed out here. He said, what makes you the judge of the facts is what makes me the judge of the law. You need to listen to what the court instructs you to do. So this question was asked yesterday when law was in here, and I feel like it's really, really important to hit on this. This is why jurors are discouraged and, well, albeit prevented, or at least supposed to be tangibly prevented from looking things up about the case, from researching the case, because the court is instructing them, the judge is instructing them on what the law is, how it applies to the case at hand. They are making a judgment on facts, the judge is applying the law. So that's why this is important here, and it's an important jury instruction to pay attention to.
Disagree with me about what the law is or should be. Your job is to take the law as I give it to you and apply it to the facts as you find them from the testimony of the witnesses and any other evidence that's introduced. After doing all that, you will render your verdict under the oath that you're about to take as jurors. Until I advise you to begin your deliberations, you must not discuss the case with anyone, including your fellow jurors, friends, family members, and anyone involved in the case. You must decide the case based solely on the evidence presented to you here in this courtroom. That means during trial, you must not conduct any independent research about the case, about the law, by searching media, internet.
What did I just tell you?
After the case is submitted to you, you must discuss it only in the jury room with your fellow jurors. The attorneys and the parties in this case have been advised that they are not to talk to you at all. So if you see anyone involved in the case and they don't say hello, they're not being unfriendly, they're just following my instructions. It's important that you keep an open mind and not decide any issue in the case until all the evidence has been presented, the parties have made their closing arguments, and I have instructed you on the law. If you become aware of another juror's violation of these instructions, you must inform me immediately. In just a moment, the solicitor will make what's called an opening statement, in which the solicitor will explain to you the issues in the case, or at least what the solicitor thinks the issues are. Counsel for the defendant may also make an opening statement, although he is not required to do so. What the attorneys tell you during opening statements is not evidence in the case. It is only their.
So, Nixie, you made a comment about sequestering a jury. So juries aren't automatically sequestered. There may be reasons in high-profile cases or other reasons why a jury may become sequestered, but they are not automatically sequestered. Normally, they're living their day-to-day lives and going about having these trials. And, to other people's points, sometimes it can be hard. It can be really hard to avoid, social media and news, and especially in higher-profile cases where you may be trying to avoid information on this. Now, you cannot actively seek it out. It doesn't mean it just can't cross your computer screen, but you're not supposed to be looking at it. Sequestering is a whole different measure. I believe we saw that probably one of the most notable cases was the O.J. Simpson case, had a sequestered jury. It was actually quite a long case, but they're not automatically sequestered.
Attention as to what the issues are or what they believe the evidence may show. After opening statements, testimony will begin. It's your responsibility to determine the guilt or innocence of the defendant, and your verdict must be based solely on the evidence as it is presented to you in this courtroom during the trial and on the law as I instruct you during and at the close of the trial. The evidence in this case will be presented to you by the testimony of sworn witnesses from this witness stand and by exhibits that may be introduced into evidence. In determining what the facts are in this case, you must decide whether or not the testimony of the witness is believable. It will be my responsibility to rule as a matter of law as to whether certain testimony is admissible, meaning whether you get to hear it. But once the testimony is admitted, it is solely for you to determine the believability of the witness testimony. In deciding whether to believe a witness, you have the right to consider the interest of the witness, the bias of the witness, the prejudice of the witness, the opportunity for the witness to have seen the matters and things about the witness may testify, and the way the witness acts on the witness stand. You have the right to consider anything that is in the record that will help you evaluate the testimony of the witnesses. That means you must pay close attention to the witnesses, observe the witnesses, listen to the witnesses, and pay close attention to the attorneys and to the court. Please don't let your thoughts wander and give strict attention to the testimony so that at the end, after all the arguments of counsel and my charge on the law, You will be in a position to determine what the applicable facts are and to apply the law to those facts and render a verdict. From time to time, you may hear one of the lawyers say something like, Your Honor, I believe we have a question of law or a matter of law to discuss with you. Or, Your Honor, may we approach the bench? Or sometimes I myself might find it necessary to excuse you from the courtroom for a short while so the attorneys and I can discuss a matter of law. The reason for this is you are the judges of the facts. And sometimes when I'm discussing matters of law with the lawyers, it may be necessary for me to make some comment as to the facts in connection with a ruling or whether or not a particular law applies. I'm not supposed to tell you what the facts are, so I will excuse you from the courtroom while these discussions take place so that in no way will you be influenced by anything that I might say or do in connection with the facts. And ladies and gentlemen,
And that's what
sometimes
judges
that may
should
seem
do.
a little frustrating for you, like we're wasting your time. You might be sitting back there in the jury room for 30 minutes while we're talking about the law. But I promise you we're working.
And we will fast forward through those
I value
sections.
your time just as much as I value mine, and I don't let lawyers waste your time. So, if you're back there, trust me, we're working. We're not talking about how bad the Gamecock baseball season was this year or anything like that.
Oh, Law, you're welcome if you'd like to come up.
So, again, I value your time. Your time is no less important than any lawyer in this courtroom or mine. So understand that we value your time very much. Now, I need to appoint Madam Clerk, will you please swear to the jury?
Yes, sir, Your Honor. Ladies and gentlemen, the jury, please stand and raise your right hand to be sworn. After this oath, please acknowledge my answering ID. Do you swear or affirm that you shall well and truly try and true deliberate?
So I want to reinforce that we're trying to look at this from the perspective that a juror would have. We're going to fast forward through any breaks where they send the jurors away. We're going to be looking at this from the juror's perspective. That's kind of what I want to do here. I think it's important because, again, you just saw the judge give the instructions, and I want to reinforce this because I think it's so important. The judge is the arbiter of the law here, but the jury is judging on the facts. He explained this to them in painstaking detail, and I already kind of went through some details on this, but I think it's important that we observe this from the perspective of a jury because we should look at what the jury looks at, so.
Made between the state of South Carolina and the defendant at bar, whom you shall have in charge and a true verdict give according to the law and the evidence, so help you God. You may be seated.
Okay, I need to appoint a foreperson, and ma'am, there next to Mrs. Cole. What's your juror number?
302.
302. Well, you pick the magic chair, so you are our foreperson. It is going to be your added duty to manage deliberations and complete the verdict form, but I'll give you further instructions on that. You're not going to get paid any more than your fellow jurors, but you will be our foreman to the conclusion of the trial. Any exceptions from the state as far as what I've just told the jury? No, sir. Anything from the defense?
Nothing on behalf of Mr. Chow.
Stay ready for open argument.
We're ready, Your Honor.
So there's no objections to how he had just instructed the jury, so that's important to know.
Please report.
Yes, sir, Solicitor.
Counsel, Mr. Kent, Mr. McCullough, Mr. Swirling. Ladies and gentlemen of the jury, what is the value of a human life? To grieving parents who've lost a 14-year-old to senseless acts of violence, a human life is priceless. But on May 28, 2023, Rick Chow, the defendant in this case, determined that Cyrus Carmack Belton's life was worth less than 4 bottles of water. I say this because in May of 2023, Rick Chow, the defendant in this case, was the owner of a convenience store and gas station on the corner of Park Lane and Springtree here in Columbia. His wife was working that evening. She was a co-owner, and their adult son was working there as well that particular evening. It was around 8 o'clock or so p.m. that Cyrus Carmack Belton, a 14-year-old, walked into that store. And he had on a red hoodie with a small pocket in the front, He was carrying a black backpack. We know this to be true because the defendant in this case, Chow, had an intricate camera system that captured almost every interaction within that store in multiple camera angles. He also had
So it
camera
means we've
angles
got good
outside
data.
of the store, on the premises of the store, and immediately adjacent to the store, so you could see what happened at the beginning of Spring Street as his property ended. So Cyrus walked into that store, red hoodie, small pocket in the front, black backpack, and he walks in and he immediately is asked by the co-owner, Alice Chow, to remove his backpack. That's store policy. Cyrus complies, does exactly what he's asked to do. He puts that backpack on the cooler and begins to walk around and browse throughout the store. He goes aisle to aisle, browsing, looking around, looking at the candy, looking at the waters, looking at other things in the store. And Alice is directly behind him, watching everything that he does. When he walks to the front of the store, she watches. When he walks to the side of the store, she watches. She leans against posts and watches everything that he's doing as he walks through that store. Their adult son Andy is working the counter, and he's watching as well. And as other customers come in to buy things, he'll service them and continue to watch Cyrus as he walks through the store. Finally, Cyrus walks to that back right corner of the store. And again, we know this to be true because of that intricate camera system that Mr. Chow installed. He walks to the back. He opens a water cooler, leans the water cooler against his left shoulder, and takes out 4 bottles of water. 1, 2, 3, and 4. And after a second, he pauses and methodically puts all 4 water bottles back into that cooler. 1, 2, 3, and 4. He closes the cooler and begins to walk back towards the front of the store. And it's at that point that the verbal confrontation begins. And I say confrontation because Cyrus said nothing. The co-owner of the store, Alice Chow, asked if he needed help and eventually accused him of stealing water, told him to empty his pockets. The adult son, Andy, who was watching, said the same thing. You took some water. Give us back the water. Cyrus said, I took nothing. I didn't take anything. I didn't take anything. And they continued to verbally attack him, accusing him of stealing water.
So the first question I'm going to ask myself here as a juror is, if they accused him of stealing things, did he indeed turn out his pockets? And if he did, right, they said he had a hoodie and some pants, shouldn't be that hard to see bottles of water, albeit even the little small bottles of water are pretty, they're sizable, right? Like, they're not just gonna blend in. I mean, maybe on a bigger hoodie, right? But it's gonna be pretty hard to take those 4 bottles of water. And to his point, if they have an intricate camera system where we can see a high level of detail, why wouldn't one person stay there with him and the other person go back to just assess the camera footage? I have to ask that question. I don't know if it's just because it's in the heat of the moment, and also I don't think you can technically detain somebody that's a law question. I would have to ask him about that, but I don't think they can technically keep him there for too long. But that's a question I'm asking myself as a juror, just something to think about.
Interestingly enough, if you look at that intricate camera system, Cyrus is telling the truth. He took nothing from that store that day. As he tried to walk out of the store, they continued to verbally harass him to the point where he took his backpack and calmly walked out of the store. Again, we know that to be true because of that intricate camera system that Chow installed. And as he walks toward that door, the co-owner, Alice Chow, says something in Cantonese that makes her son run around the counter towards Cyrus. And then Chow, the defendant in this case, comes from out of an office in the convenience store, armed with a .45 caliber Glock pistol, and follows Cyrus out of that store. Cyrus walks out of the store, takes a right.
Oh, real quick. Okay, so law says shopkeeper privilege allows stores to detain, but only if they actually stole something, not supposition or suspicion. I gotcha.
Slowly,
Thank you, law.
and hears them yelling, running after him. Turns to see, and again, the camera system shows these things, and he takes off running. Cyrus tries to run through the parking lot to the point to where he runs out of his Air Force One Nike shoe. Runs out of his shoe. Doesn't turn around to pick it up because you have an adult male running behind you with a .45 caliber Glock pistol who has falsely accused you of stealing.
People have asked, like, and I'm again, this is part of the prosecution's opening, so we're gonna get into the nitty gritty of the details here. But people have asked, well, why was he running? If you see somebody with a firearm starting to chase you, yeah, motherfucker, I'ma run too. It's like, it's not an officer, there's nothing like, and I didn't steal. Yeah, I'ma fucking run too. I'm sorry. That's absolutely, like, people have asked, now you know. At least from the prosecution side, bro was chasing him with a whole 45, I would have run too. Like, at least if this is factually accurate, because he's painting a story right now, right? Like, he's painting his side of the story, so we'll need to see what happens. But yeah, if you're chasing me with a firearm, yeah, I'm gonna fucking run.
So he runs. He drops 2 cell phones out of his pocket. We know this to be true because there are witnesses who we expect you'll hear from who'll talk about how they had to throw on brakes to keep from hitting them as they ran across traffic. We know this to be true because of that intricate camera system that he installed. He drops 2 cell phones. One belonged to him, one to his mother. Doesn't turn around to pick up one of those cell phones. Continues to run, falls down, gets
He's
back
trying
up
to
running,
establish some
falls
legitimate
again,
fear here.
busts his shin, drops the backpack, keeps running. In total, Rick Chow and his son chased Cyrus Carmack Belton over 130 yards off of their property onto a public road in Columbia, South Carolina. And eventually, after Cyrus fell a couple of times, Rick Chow fired the fatal shot, which ended his life. And folks,
I don't do the sports ball thing, but maybe somebody can tell me this real quick. In terms of a football field, what's 130 yards? Is that like half? Like, I'm literally telling you, I don't fucking know. Like, I know there's the 50-yard, I mean, like, in terms of, like, because I can conceptualize a football field. Like, how far is that? 1.3. Thank you, Law. You're the best. I love you for that. Thank you so much. So, yeah, of 1 1/3 of a football field, he chases this kid who he thinks stole some water with a gun. Think about that for a second in your mind. And now we're going to get into the defense, and I'm sure the defense is going to have some good points too. Like, we'll get into this, but like, this is stuff I'm trying to conceptualize if I'm sitting on this jury right now.
130 yards is a football field. No, in
Thank
fact,
God
it's a
you
football
wasn't the only
field,
one.
Goalpost to goalpost plus 10 yards.
Man, I should have waited.
Ladies and gentlemen of the jury, I'm Byron Gibson, the 5th Judicial Circuit Solicitor, and I, along with Dale Scott, Stephanie Taylor, and Weston Leifer, represent the state of South Carolina. So for the next few minutes, I'm going to give you a little bit more of a roadmap of what this case entails, what our position is in this case, and what we believe we can prove, as well as give you an idea of what to expect from the court and how this proceeding will run for the next several days. Now, I mentioned to you a moment ago that when Cyrus walked into that store, he was wearing a red hoodie and a pocket in the front, black backpack. Unbeknownst to the Chow family, to Chai Rick Chow, to Alice Chow, or to Andy Chow, he had a pistol in the front pocket of that hood. Unbeknownst. They didn't know. We know that to be true because that video will confirm all of those things. Confirm that he walked around the store, had a conversation with them. At no point did he ever threaten them. At no point did he ever curse them when he was being falsely accused. He didn't spit on them. He never attacked them. He calmly walked through the store. And
I want to point out, like, for me, I think he's trying to soften the blow of when this gets brought up. I'll tell you, I don't know a lot of the facts on this, but I'll tell you something that makes not a damn bit of difference unless he took that gun out and pointed it at them, is that he had it in the first place. Yes, it's illegal. It's a problem. It's maybe a moral failing or whatever you want to fucking call it. But unless he took that gun out and pointed it at Rick Cho, and then I don't even know if at that point, because if he necessitated the chase, like, I think it becomes like, we talked about this last night, Law can talk about it more when he comes up here, but like, regardless, unless he took that out and pointed it at him, it doesn't matter, but because it's going to be brought up, I think it's what he has to do. I like that the prosecution, yeah, frame it, yeah, exactly, thank you, Law, I appreciate that, because, yeah.
And calmly denied stealing anything from that store, which again was true. The truth in this case is that Cyrus did what you'd expect an adult to do in that case. He walked away. He tried to create distance every time he was confronted. But for some reason, Chai Rick Chow wouldn't believe him. He couldn't believe him for some reason, although the evidence will show that he took nothing from that store. The evidence will show that after they chased him out of his chute, dropping phones around down Springtree Road, after he tripped over a curb, fell, dropped his backpack, we believe that gun spilled out of that pocket. And within moments after that gun spilled out of that pocket, that man shot Cyrus Carmack Belton in the back with a 40.
Okay, so see, this is where I think maybe the defense is going to come in and say that that gun came into play in a different way. Now, I don't know if we have a recording of it. If you're talking about a fucking football field, I doubt they have recording that's that good. So I think then the question then becomes is like, did it slip out of the pocket? Did he pull it out of the pocket? Like, I think that's where this sort of comes in on the defense side. And we'll find out because he's going to do his opening soon. But then that's the question I'm asking myself. Did it slip out of the pocket? Did he take it out of the pocket? And again, I don't think any of this was worth anybody's life. Like, I think this is absolutely ridiculous. However, that's the question I'm going to have, like, I would be asking myself right now.
45 caliber pistol. Now, we believe evidence will show that soon after EMS and others came on the scene, Chai Rick Chow tried to say, hey, I was defending my son. But the interesting thing about this process is that you're going to have an opportunity at the end of this case, that you've heard all of the evidence from this witness here, to assess what you've learned and what you've heard. You get a chance to assess that, and I'll ask as you start asking those questions that bounce around in your head, in what world do you get to falsely accuse a 14-year-old of stealing, chase a 14-year-old 130 plus yards down a road while you're armed with a pistol, shoot that person in the back, then claim you're defending your son? Folks, it's for that simple.
And I'm going to fall back here too because I just thought about this. Okay, so like Rick Cho is, I'm assuming, at least from what the prosecution is alleging, chasing him with a visual like firearm. Like he can see this firearm. Now, again, I don't know. Defense hasn't presented their opening. We're going to get into the facts of the case later. Prosecution's laying out their side of the story. But okay, so I'm also going to ask myself, if he's chasing him with a gun, regardless of whether he could have this firearm, that's not something I'm worried about here. Was he necessarily wrong while still being chased to pull out the firearm? I start having a lot of questions. Again, I don't like 14-year-olds having pew-pews. It's not what I'm advocating for in any way. But I'm just going through the questions that are happening in my mind because I'm trying to see it from the perspective of a juror. So,
Senseless act, for that ridiculous act, for that heinous act, that Chai Ki Rick Chow, the defendant in this case, has been charged and indicted with the crime of murder. And it's for that crime that we, the prosecution, Dale Scott, Stephanie Taylor, and Weston Leifer, will be asking that you return a verdict of guilty at the appropriate time. Now, as prosecutors, we have something that's called the burden of proof. And what that means is we have to prove beyond a reasonable doubt that Chai Ki Rick Chow murdered Cyrus Carmack Belton. Now, reasonable doubt in South Carolina, our courts have defined it a couple ways, and I'll explain those to you. Reasonable doubt is the amount of doubt that causes a reasonable person to hesitate to act. The amount of doubt that causes a reasonable person to hesitate to act. There's an alternative definition that says that if you are firmly convinced of the defendant's guilty, and at that point they are guilty of a crime. But that's for you all as the jurors to decide. Now, as was mentioned a few moments ago, Judge Taylor is the judge of the law. And you've got to take the law as he gives it to you. So at the appropriate time, he'll advise you of the definition of reasonable doubt and every other legal standard and every other thing about the law that you're going to need to know. He'll advise you of those things at the end of the case at the appropriate time. But the cool thing about this process, just as he said, is that as Judge Taylor is the judge of the law, you guys are the judges of the facts. And you get to determine based on what you hear from this witness chair and the evidence that you observe, you get to determine what actually happened in this case. So you're probably asking, all right, well, how am I supposed to do something like that? How am I judging people about, as a witness? I suggest to you that just as you are judging my credibility and believability right now, that's a skill that you've developed over all these years that you've been walking this earth. I suggest to you that when you parked your cars this morning, you didn't leave your common sense in the parking lot. That's what you're using to assess credibility.
I kind of like this prosecutor. He's interesting.
With each of the witnesses,
I like the way he's framing it.
You'll judge that. You'll talk. You'll have an opportunity to determine if they had motive to say what they say. If they could observe the actual things that they're saying they observed. If they have some reason to change or to try to tell a story in a way that's going to help them. You'll get a chance to make those determinations at the appropriate time.
Agreed, Law.
And we'll ask that you do that.
Want to see the defense attorney.
A couple moments ago, each of you guys took an oath to well and truly try the facts of this case. And what that essentially means is that you got to try the facts of this case. Not some stuff that you may have heard out there, not some preconceived notions, not some ideas that you may have, but from the evidence that you hear in this jury room this week in this case. That's what you've got to do. Folks, I ask that you resist the urge to turn this trial into some type of commentary about youth and guns, because it's not about that. It's about a grown man who falsely accused a 14-year-old of stealing, chased him down the road while armed with a pistol, shot him in the back, and then claimed he's defending his son. That's what this case is about. And ultimately, those
But defending his son against what? That's my question.
Now, I expect that you're going to hear from several different types of witnesses this week. Some are going to be what we call lay witnesses, just people who just happened to be driving up and down Spring Tree Road that day. Folks who saw what happened. Folks who watched the Chows chase Cyrus across the street and shoot and kill him. We expect they'll have different vantage points, seeing things in different ways, but you'll have an opportunity to listen to them and assess what they saw. You'll hear from law enforcement, first responders, people who saw what happened and talked to witnesses out there on the street immediately after it happened. Some body cam meaning the body cameras that they're wearing when they're talking. You'll see some of those things. Take that information. You'll also have an opportunity to hear from a few experts. And judge will explain to you what experts are and what expert testimony is and how you weigh expert testimony. Again, take the law as he gives it to you. And take the law from experts and determine if they have the ability to testify about the things that they say that they know and how they came upon this information. And if this information was paid for, ask yourselves those questions at the appropriate time.
That's the interesting thing about expert witnesses
You're going to
is
hear about 3 types of evidence. So I'm
should be
wrapping this thing up. And once I get
unbiased,
this early in the
but
morning, there are going to be 3 types of evidence you're going to hear about. One is direct evidence. Second is circumstantial. Third is stipulations. Direct evidence is evidence that you can see, that you can touch, that you can feel, and sometimes even smell. Circumstantial evidence is evidence that you can infer exists based on a series of facts. All right? Evidence that you can infer exists based on a series of facts. So, example, we're sitting in here, South Carolina, it's probably going to be 80, 90 degrees with 100% humidity. If you walk out here at lunchtime and you see snow outside, it's 12 degrees outside. You see icicles hanging off of the different the posts and all that kind of stuff. You see a snowplow going through here. You see penguin tracks and maybe a polar bear walk by. You are in this room with no windows all day, but you can infer that it snowed because you see all of the evidence of snow. That's circumstantial evidence. It's just as good as direct evidence if you, the jury, determine that you believe that that's what took place. So direct evidence, circumstantial evidence, and last we're talking about stipulations. Stipulations are agreements between our table of state and that table of defense team. They're stipulations. That means we have an agreement that a particular fact exists. And if we have that agreement and we alert judge that that agreement exists, then judge will have the opportunity to explain to you that that's not a fact that you guys have to haggle about or even argue about, because we agree that it's the truth. So direct, circumstantial, stipulations. Those are the 3 types of evidence we'll be talking about. And at the appropriate time, you'll
I
have
like the way that he's explaining this. He's making it very
facts of the case,
easy for them to
and with the
understand.
evidence, you compare that to the evidence and return a verdict that speaks the truth in this case. Now, my final ask of you is this. There's an 11th century philosopher named Omar Khayyam. And one thing that he wrote back then was, "The moving finger writes, and having writ moves on. Nor all your piety nor wit shall lure it back to cancel half a line, nor all your tears wash out a word of it." Now, I know y'all are looking at me kind of like, what is this dude quoting some 11th century philosophy for? I'll tell you that at the end of this case, I will explain to you why something written back in the 11 and 1200s rings so true today in this courtroom in 2026 about a case where that man murdered a 14-year-old in 2023. So, folks, remember what we've talked about.
I'm not sure, Law. I didn't get to see that portion of it.
What is the value of a human life? Thank you.
Please record. Yes, Mr. Sloan? Solicitors? Yes, sir.
Well, I didn't see this one coming.
My name is Jack Swirling. We met briefly yesterday when we were doing the jury selection. And it's my
Grandpa
position at this
Time
point
is
to go ahead
defending
and
him?
give you a defense opening statement. And I appreciate you being here. Thank you for being here, and I hope that you find this experience on your part to be an interesting experience about looking into your judicial system. You know, we spent, let me just back up a minute. My good friend, the solicitor, just gave an outstanding opening statement himself. But the one thing that I did not hear And the one thing that I do not believe you will hear during the course of
Law,
this
this is
trial
going to be wild.
is
I just
why
have that feeling.
a 14-year-old would be illegally possessing a semi-automatic pistol,
There it is.
wandering the streets with that pistol, with a laser attached to that pistol. A laser to go ahead and ensure.
Oh my fucking God. Okay. We're going to stop right here. This is hyperbolic. And again, they're allowed to do it. They're setting up their side of the story. I get it. Like, I'm not challenging that he can't say this stuff. What I'm saying is that this is hyperbolic. And unless he pointed it at somebody, it does not fucking matter at all on the circumstances of whether Rick Cho is guilty of unaliving him. Like, again, it's a terrible fact, but it's still a fucking, like, it's not relevant unless he pointed it at somebody. Yes, exactly. Thank you, Law. Irrelevant, emotion baiting. Yes, very hyperbolic. And the laser, like, fucking laser, like, what did he have, like a light on it, like a flashlight, or like the fucking, what am I trying to think of right now, little attachment, like a sight. That's what I'm trying to think of, a sight.
Ensure better accuracy when you fire the weapon. A semi-automatic pistol that was loaded, the magazine was loaded, and there was a bullet in the
Why
chamber.
would you have a fucking gun that's not loaded?
It was illegally possessed by this young man. He illegally entered the store because there was a sign posted, it's illegal to go ahead and enter the
Somebody
store
will
with a
say
weapon.
they saw the laser flash.
Versus what Mr. Chow did. Mr. Chow had a concealed weapons permit.
Yeah, but like, okay, my question is, Law, right? Okay, if somebody says that, even if they do say it, right? If it falls, can it not like accidentally like turn on or turn off or something like that? Like, I don't have anything like that on anything that I have. I know you can add that stuff, like, and that's too fancy for my shit. But I would assume that if it's falling, maybe it could, like, kind of flash or something like that. That would objection mistake. Oh, okay, hold up.
He never drew his weapon. He was authorized to have a weapon, but he didn't draw that weapon until his son was in danger of being shot.
Boy, how?
The solicitors, in this case, want to frame this case. It was all about a bottle of water. It was all about someone wrongly accused of shoplifting in the store. But nothing else matters to the state in this situation as to why this young man had that weapon, why he carried that weapon. Because if he didn't have that weapon,
Interesting, Law. Thank you.
he never would have had a weapon to draw on Andy Chow. He never would have had a weapon to put Andy Chow in danger. And he never would have had a weapon that would cause Mr. Chow to believe his son was going to be shot and have to make a split-second decision
I better be seeing
Split-second
some
decision.
video on this shit.
as to whether or not to go ahead and
Okay, listen here. Grandpa time is compelling, but all of this is hot fucking nonsense. From, like, I want to see the video. If at any point, Cyrus points a gun or makes some sort of threatening measure towards the son, I'll take this a little bit more seriously, right? Like, but we're gonna need to see this because of the intricate video system that was described. Like, I should be able to visually see this occur. Otherwise, he's not in danger, he's fucking fine, and your husband chased after the man with a gun. I'm already making some takeaways, but I'm speculating that maybe what we see in the video isn't quite that. He's really pushing this hard, and I already have some questions because he's coming at it in a very hyperbolic way. Well, you shouldn't have had a gun. He blah, blah, blah. Well, he fucking did. And whether he did or not, it's not illegal unless he fucking, I'm just saying. I mean, it is illegal for him to have it as a minor, but it's not, unless he pointed at him, it's irrelevant in the murder issue.
And fire that gun and protect his son. There's going to be a lot of questions in this case, a lot of things that you're going to have to resolve. But I want to go ahead and tell you why this case is framed the way the state is doing it, because they don't want to explain why that young man had a semi-automatic pistol, loaded, bullet in the chamber with a laser, entering the store, wandering the street.
Again, I'm going to say this again. I'm going to say this for the last time because they don't have to explain it. It's a fact, but it's not relevant unless he did something with it. Him just having it, shitty, yeah, and illegal. He's a minor. He shouldn't be in possession of a weapon. And then I would have some serious questions for his parents or whoever he got it from. But it's wholly irrelevant to what happened in this case.
They don't want to.
Sorry, I'm yelling.
You know what? They cannot. We went through a jury selection process yesterday that's carefully designed to go ahead and make sure that 12 people who will eventually decide this case, 12 people from Richland County, who are fair and impartial, who do not have any preconceived opinions, who've come in here under oath and said, I may have heard about the case, but I have not formed an opinion about it. I'm willing to listen to the evidence and the law that the judge gives me and decide this case fairly and truly and honestly. We went through a jury selection process where, as you recall, the judge excused a number of witnesses for one reason or another to make sure we had a fair and impartial jury. The state excused witnesses because the lawyers, both sides, are entitled to go ahead and make challenges to witnesses or peremptory challenges. They have challenges that we can exercise because any reason whatsoever. However, what it comes down to is that both the judge, the state, and the defense believe that we have the 12, 13, 14, 15 jurors now who are the most fair.
Law,
and
he's
impartial
like
jurors
950
who can
years
sit in judgment
old.
on this case and decide whether or not Rick Chow.
No, I'm saying old people can't do a
He's
good
guilty
job.
of
It's just
murder.
awkward. I was
Whether
not
or not
expecting that.
He intended to kill this young man, and he did it with malice, an evil heart, a wicked mind. That's what judge will describe to you what malice means. And you will have to decide whether or not the state has proven that case beyond a reasonable doubt. So we are satisfied. We are content that we have the best.
Oh yeah, he does kind of look
jurors
like
that
Doc
will
from
come out
Back
of
to the
Richland
Future.
County to decide this case, and we have faith in you. Rick Chow has pled not guilty to this offense, and that places on the state the burden to prove guilt beyond a reasonable doubt. Now, I just want to cover a couple of legal issues, legal principles with you. One is, as he sits over there right now, and throughout the course of this trial, all the way through, he is presumed to be innocent. That's not just a legal fiction. That's not just something you hear on TV and Law and Order or some other one of the great police shows or law enforcement shows on TV. The presumption of innocence is the bedrock of our judicial system. Everybody accused of a crime is presumed innocent unless and until the state proves guilt beyond a reasonable doubt.
Holy shit, nobody ever would have guessed that.
Presumption of innocence is so strong on our law that you are to consider and presume Mr. Chow innocent unless and until, at the end of the case, after you've heard all the evidence, after you've heard the judge's instructions on the law, you go in the jury room.
Okay, so like I'm gonna like tell you it's compelling but overly emotional for me. And I don't know, maybe it's just because of my previous work, but like that would be sending up red flags for me. Now, I agree with law. I felt like the prosecutor didn't lay out as good of a story as I would want him to. But this guy is just like, it's hyperbolic waffling all over the place. Like, yes, of course, people are innocent until proven guilty, but it's a lot of like, very much, oh, well, why did he have a gun? Well, it doesn't fucking matter unless he did something with. I would have red flags all over the place. I don't know why it's me, but I would have red flags all over the place.
And 12 of you.
And I do defense work. Like, I'm not big on like the state
agree
fucking finding people guilty, but
that the
Jesus.
state has proven guilt beyond a reasonable doubt. That presumption of innocence does not disappear during the course of this trial. Now you may say, well, that's kind of difficult. It is our law. It is what makes us different than everybody else on the face of the earth. The state has to prove guilt beyond a reasonable doubt, and until you go in the jury room and decide that the state has met its burden of proof, he's presumed to be innocent. Now, proof beyond a reasonable doubt doesn't just mean any doubt, but you have to prove the case beyond a reasonable doubt. In other words, I believe, or I think, maybe, any one of these words, that is not enough to go ahead and convict someone. It has to be beyond a reasonable doubt. It's not enough.
I want to count how many times he can say beyond a reasonable doubt. I think I'm on at least 20.
I think the state proved guilt. I mean, that's not enough.
I mean, it's important,
It's
but
beyond a
like
reasonable doubt.
20 times seems excessive.
Reasonable doubt can come from the evidence or the lack of evidence. Either way, you are the ones who determine whether or not the state has met its burden of proving the case beyond a reasonable doubt. You're the ones that apply the presumption of innocence. Not the judge, not the lawyers, not the parties, but you. The state also has a burden of disproving self-defense. And this is a case of, it's a side, or it's a collateral issue to self-defense, whether or not someone has a right to exercise self-defense and take another human life.
Okay, so this is where it's going to get interesting.
It's probably the oldest principle we have as man. All the way back. You have a right to defend yourself. You do not have to wait and someone goes ahead and shoots you, kills you, or stabs you, or no matter what it may be.
Well, it depends on what state you're in, but sure.
That a person has a right to exercise self-defense, the law of self-defense, to defend himself or herself. And it also applies to defense of others. Same principles. You are entitled to go ahead and defend other people in a similar situation. For example,
Okay, so this is where I'm going to really wonder where this is going to go, right? I'm going to have to ask myself that question of where this is going to go, because at least from the framing we have right now is that the prosecution, laid out their side, but this jury really believed like there was beyond a reasonable doubt that maybe this man really was just defending his son. So while I can talk shit about his opening and dislike it, I want to see what facts they get into, because I need to know how the jury got to the place that they are at. Like that's the real question I have now. Oh, me, Barta? The mic I use, it's a Shure mic. I got it on sale during Christmas for like $150, so yeah.
Your son, which is exactly what we have here. Because if the state doesn't prove beyond a reasonable doubt that Rick Chow did not
That's what we're getting to, Cynthia.
act in self-defense or defense of others, then they fail. They have failed to prove the case. There's no burden on any defendant to prove anything in the case. So the state has to prove guilt beyond a reasonable doubt, and they have to disprove self-defense or defense of others beyond a reasonable doubt. And we know that you're going to hold them to that burden of proof and keep our system the way it was designed to be. That a jury sits between the state or the federal government and the citizens in a county or in an area and decides cases fairly and impartially, and that no person is ever held to answer for a crime where the state has not met its burden of proof. The judge will describe to you what the definition of murder is. And I told you it's malice aforethought. That's what South Carolina standard is. Murder is with malice aforethought. You kill somebody with malice aforethought, that evil heart, that wicked mind.
But that's important. That's actually an important
Offensive
component
murder also
here, right?
requires
Like,
that the
did
judge
he do
declare
it with
criminal
malice?
intent.
That is something you need to know.
You have to have a criminal intent to go ahead and be guilty of a crime. You had to intend the crime. And the judge will explain that to you at the end of the case as well. And I'm not going to go into the details of it, but I just want to turn these principles over to you so you know what we're talking about. Self-defense, defense of others.
Thank you, Ellie.
Was there a reasonable belief or an imminent danger? Was the imminent danger, and you believed it was reasonable, and it was reasonable, that someone's life was in danger, your own life or the life of a loved one, like Andy Chow? Under those circumstances, you are entitled to go ahead and exercise that self-defense or defense of others. And the judge will explain to you, as I just said, that it is up to the state to disprove that. You will hear evidence of that. You will hear in detail exactly what happened out there on that street and what happened when Rick Chow went ahead and fired the shot. The young man was pointing a gun at his son. Defense of
Okay.
others. Is that a
There
immediate
we
threat,
go.
an imminent threat?
Fucking, fucking talk about taking a long way to get to the end that I want to know. That's what I wanted to know. Is that the allegation that's being made? That a gun is being pointed by Cyrus at somebody. On the prosecution side, that was not part of what was leveled. But on the defense, they're saying, nah, he pointed this. And then I'm gonna wonder, because at least from how the prosecution had set it up, Anthony and the mom the son Anthony and the mom were in the store. So where and when was this gun pointed is the question I'm going to start having. But yeah. Also, please, if you can, send your daily heart muse, because that helps a lot. Okay, love you. We'll get back into this. Thank you.
Is it a reasonable belief that your son is in danger of serious bodily harm or death? I submit to you there's not going to be any question about whether or not it was reasonable or whether it was imminent, or it was reasonable to believe it was imminent. And you are, under the law, since the beginning of time, allowed to go ahead and take, unfortunately, nobody's saying everybody's happy about this, but unfortunately, there are occasions in human life when someone has to exercise that right of self-defense or defense of others, and another life is taken. It's sad, it's tragic, there's no question about that. My heart goes out to the family. they've suffered a tremendous loss. And I don't want you to think for 1 minute that we're making that light about that. This was a terrible situation that happened, and that young man is no longer with us. But there are legal issues that you must decide prior to making any determination about guilt.
I like how he did that, though.
And
There
we
wasn't a
submit-
but.
I submit to you
I'll
right
give him
now
credit on that. I like how he did that. He
that the
said,
state
this is horrible.
will not and
We're not
cannot
making
meet
light of
its
it.
burden of proof.
We have to look at the legal
Proving
issues
guilt
in this
beyond a
case,
reasonable
though.
doubt.
I didn't
Proving
feel like there
murder,
was a but. I
malice
felt like
aforethought
he
beyond a reasonable doubt. Criminal
did that
intent
correctly.
beyond a reasonable doubt. Or disprove defense of others, as a judge will explain it to you. Now, how do you decide that? Well, you're going to listen to the evidence. You're going to hear the law by the judge, and you're going to make your decision based upon that evidence that you hear and the law that the judge gives you at the end of the case. There's no schooling. There's no, we don't have any classes to how to go ahead and determine that. But I will tell you this. Reasonable doubt is something you use and exercise every single day when you make the important decisions in your life. Should I go to that school? Should I buy that car? Should I buy that house? Do I need this? Do I need that? You weigh the factors, both the pros and the cons. And no matter what the pros and cons are, you're still entitled to go ahead and make that purchase or go to that school or go on that trip, even if it all adds up to being not the right thing to do. But when you come into a courtroom, it's completely different. Because if you have a reasonable doubt, if things just don't make sense, if it doesn't add up, one thing after another make sense, and come to a conclusive decision that the state has proven guilt beyond a reasonable doubt, you can't disregard that. The oath that you just took requires you to find someone not guilty or not proven is another way to look at it. Not proven beyond a reasonable doubt. Submit to you at the end of this case, again, hearing the law and the evidence or the lack of evidence, you will come to that decision that the state has not met its burden of proof as to proving the case or disproving self-defense or defense of others. You look at the evidence, you listen to the witnesses. Are they consistent? Have they told the same story, everything that they've seen, everything that he did? Is it consistent all the way through? Not only is it consistent between what they said, but consistent with what other people said. And not only consistent with what other people said, but is it consistent with the physical evidence that you know and that you see and is presented to you in the courtroom? You look at motive and interest and bias and prejudice to decide whether or not to believe a witness or the credibility of witnesses. You are the folks that decide the credibility of witnesses. I want to go ahead and, as I've said, it's a tragic situation. My heart goes out to the family that they've lost a terrible loss. Nobody can understand that. Nobody can in any way comprehend what it would be like to go ahead, and I feel sorry for these folks. And I feel sorry for the young man who lost his life. But it's also about the Chow family. Rick Chow and his wife Alice Chow. Rick was born in Hong Kong. Alice was born in Malaysia. They came here early on in life as students. They went to Louisiana, University of Louisiana. Rick Chow and
through
Alice
part
Chow
of the
became
defense's
citizens of the United
opening
States.
right now, Jen.
As proud American citizens as
You actually
anybody
didn't
could
miss much.
possibly be.
Just storytelling.
They married. They had 2 children, Andy and Kenny, who've both gone to the University of South Carolina. Alice was a CPA, earned her CPA degree and a license. And Rick Chow was a professor at Upper State Carolina for a number of years in computer science. These are motivated, energetic, people who wanted to pursue the American
Welcome
dream,
back, Law.
and they did. At some point, they wanted to go ahead and own a business, and that's how they came to buy the store that's in question today. They had that for about 10 or 12 years. They bought it. It's a Shell gas station. And they bought the store, and they operated it. Rick Chow really wanted to go ahead and form a business.
Hi,
So
Teddy.
for 10, 12 years, they've operated that business. In May, as the solicitor has told you, the situation that's before you today, young man, Carmack
Dear
Bell,
sweet Jesus, get on with it.
entered their store. Now, when he entered the store, he had a backpack. Backpacks have to be put on the water cooler. It applies to everybody. They don't want anybody walking around in the store with a backpack. So everybody puts it on the water cooler. Mr. Belton Carmack did. Put it up. You will find out, we'll talk about what's in that book bag later on, but the young man entered the store.
Don't make me speed you up, motherfucker. Hold up.
The store, not buying
I can't be
anything,
dealing with grandpa time here. We
Looking at
gotta
different
get
merchandise.
moving. Come on.
Not buying anything. Going to the water cooler, strangely removing 4 bottles one at a time, then strangely putting them back.
I did the
one at a time.
1.25. People cry if I do
Looking
1.5.
nervous, hands in his pockets. Looking back at Andy Chow, looking back at Alice Chow, who was on the floor at that time. They were both in the store in a nervous way. And they had a suspicion that he possibly had shoplifted something. Now, this is a store with thousands of small dollar items. A water bottle or any other item in the store, probably very little profit in it. So it's not about whether or not one item was ever taken. It's the cumulative effect and the losses.
The fuck
The
it
store-
isn't. Hold on. Stop. We're all gonna
Go ahead,
stop.
White,
We're gonna
go
take
ahead.
a stop for a second. Okay. Wait. It's not about whether anything was taken. I want to preface this with bro chased after this young man with a 45, now saying he was protecting his son, which okay, sure. But what started all of this? What precipitated all of the events that occurred? The fact that they thought that he stole something. It's absolutely relevant. I don't care. Maybe I'm wrong. I don't know. Law, you can weigh in on this one, but it's absolutely fucking relevant. Sorry.
See if anybody's taking anything. When Mr. Belton was leaving the store, he was asked, "Did you take anything?" And he basically had his hands in his pockets and he turned it up, the pockets. "No." "Do I look like I have anything?" He was asked again, and at that point, he went to the water cooler, picked up the book bag, and at that point exited the store. There was no physical confrontation. There was no yelling at him. But
So
there
he
was a
left because he
question
didn't fucking
that he
steal
answered.
anything?
But
Crazy.
Andy Chow still felt that there was something about the way he was acting in the store, and he wanted to follow, at least to see where he was going, so they could report that to the police. He could report it to the police. But at that point, when they exited the store, Mr. Belton, Carmack Belton, started running. Now, he saw something that he thought, Andy Chow saw something and he thought looked heavy in his hoodie, in the pockets of his hoodie. And that could have been something that he took, like the water. Well, we now know that it wasn't the water, but it was a semi-automatic loaded pistol with a laser on it.
Nobody
those
fucking
pockets.
cares.
So he was telling the truth, that he saw something heavy in the pocket. The suspicion increased when the young man took off running. Why was he running? Why did he run? He did increase the suspicion at that point by running.
He keeps saying semi-automatic pistol, but what kind? Are we talking like a Glock 19? We talking one of those little baby things? Like, that's gonna look way different in people's fucking pockets. I'm just being real. Oh, Lord.
And he really ran fast because he ran out of one of his shoes. He threw the phones down before he exited the parking lot. And he just took off as fast as he could. Now, reasonable to believe that he may have taken something? Absolutely. Reasonable to go ahead and follow him to see where he was going, what direction, so he could tell the police? Absolutely. And he wasn't going to tackle him, he wasn't going to hold him, he wanted to see where he was going. Rick Chow had come out of the office, and he saw his son outside, and the young man outside as well, and he saw him take, both of them take off running. Rick Chow, the defendant in this case, ran following his son and Mr. Carmack Belton because he was trying to see what was going on with his son, protect his son, make sure his son was okay. He did not know what was going on. He had nothing to do with the determination in the store.
Listen to what he just said. I want to we can roll it back if I need to, but listen to what he just said. He followed, but didn't know what was going on. So he follows to not protect his son, because if you don't know what's going on, I don't know how you can allege protection at that point. Maybe it happens down the road. Let's find out.
But he was going out there to protect his son, to make sure his son was okay. It's his son. And the young man hauled down the street, crossed over the street, ran down on the left side of the street toward the apartment complex. And at some point, he tripped, fell. Mr. Chow was behind him. Andy was somewhere, you'll hear the testimony about it, somewhere in that area on the street. And actually, the young man hurt his leg, cut his leg. But when he got up, and by the way, he also threw his book bag into a ravine down there. Why? What, do these things increase?
Because when you're fucking running, it's heavy.
But when he came up, and Andy Chow saw that he had a pistol in his hand. It turned out to be the 9mm pistol. That one in the chamber was loaded and had a laser that had been attached to it, but the laser was found.
Keeps harping on the
in
fucking
road, right
laser.
near the road where the shell casing that was fired out of Mr. Chow's weapon landed. Now, Mr. Chow never pulled out that weapon. The state wants to talk about, well, you know, he ran from somebody who had a .45 automatic, semi-automatic. How would the young man know that? He didn't even see Mr. Chow. Mr. Chow had it in a holster the whole time. He did not pull out his weapon from the holster until.
Just a
Overruled. Go ahead, sir.
He didn't pull out his weapon.
I didn't hear the objection.
Until he was told by his son that the young man had a gun. The young man, Andy being a young man as well, when he saw the gun, started backing up like this, had his hands up, backing up into the street. Mr. Belton pointed the gun at Andy Chow. Mr. Chow told him, drop it. He didn't drop it. Andy yelled out, he's got a gun. He's standing in the road. Mr. Chow is coming up, pulls his gun now. At that moment, at that split second, that frozen moment in time, Rick Chow sees a young man pointing a semi-automatic pistol at his son, who's backing up with his hands up, and Rick Chow fires his gun to protect his son. We submit to you that that was reasonable. It was a reasonable impression that his son was possibly going to get seriously injured or die.
Okay, given that if the set of circumstances are believed to be true that he's putting forward, I would say that that could be reasonable. He was actively pointing a gun at Andy, according to the defense. Again, I don't know. We're going to get into the actual facts of this case. We'll hear from witnesses. But given if these set of events are true, that is a reasonable reason I would believe to discharge a weapon. So we need to figure out what's going. Oh, thank God, Law's here. He's low. Oh, there he is. What's up, Law?
Oh, just living the dream.
I know you're just having fun listening to this shit with me. Um, yeah, I was just saying that if that given set of facts is true, right, or well, whatever he's presented, right, that like the young man pointed the gun at the son, would that be a reasonable reason to discharge a weapon? Like, I agree he shouldn't have been in pursuit, but like at that point, would that be reasonable?
Yeah, so what the defense is trying to do here is bifurcate the circumstances.
Yeah.
So the step one was they were going to follow him to see which way he was running so that they could call the police and report the stolen item. So that's step one. And then they're proffering that now a new encounter happened when a firearm was presented, and then Chow used his firearm in self-defense. I'll be very curious to see if there's any witnesses that can corroborate any of this as we continue watching, because sometimes if you unalive the only other witness, then you get to tell the story.
Yes, that's exactly true. That's why I was like, I want to hear from the witnesses on this. Apparently this happened in, I'm guessing, a busier area because he's alleging traffic and people had to stop and things like that. So I'm like hoping that somebody else saw this occur, like was able to see this occur, because that's going to be very different than just like A or B. I agree with you. You dead bodies tell no tales kind of thing. So yeah. Okay. Are you ready to get back into it, or did you have any thoughts you wanted to weigh in on first?
Yeah, the prosecution opening wasn't as strong as I would have liked. Typically in a murder case, in your opening, you go through chronologically like what happened, and he kind of skipped around between points, but you want to tell a narrative of he kind of just jumped from the bottles to the confrontation to now he's dead. I would have liked to see some more narrative put behind that to show that this is a kid running for his life from people who are armed and chasing after him. I think it would have been a little bit more compelling. And now when you listen to defense just laid out a very convincing, if true and if proved, narrative of why self-defense would have been justified. And I just didn't get that feeling from the state.
Well, and that's what kind of like, it's going to make me ask that question. And again, we're going to get into the facts and later, but like, what if the prosecution's facts are just bad? Like, I mean, I'm, I guess you can spin it so many ways, but like, what if it's just not a solid prosecution? And then start having to ask the question, the defense is laying this out. Like, I don't know. It just makes me wonder. Like, it makes me wonder about things.
Well, like what I would have done from the state's perspective is, I'll have to take a shower after, putting myself in the position of a prosecutor. But I would have said, absolutely, the young man shouldn't have had a gun. And if Mr. Chow would have done what he should have done and just called the police, it's very possible you'd be sitting in his trial for illegally possessing the gun. But the gun has nothing to do with the fact that he was murdered. I would have done that because it would have probably built some goodwill with the jury for the prosecutor to concede that, hey, he shouldn't have had a gun, and I would have prosecuted him if that case came across my desk. But Mr. Chow should have called the police. He didn't need to go chasing after somebody for 4 water bottles. He didn't need to shoot somebody over a thought that somebody stole a water bottle and then, like, kind of appeal to the jury. Are you kidding me? Whose life is worth water bottles? He chased after him with a gun and shot him because he thought he stole water bottles. I mean, I think that would have been a more compelling story to the jury.
Well, and something that the defense said that I thought was interesting, right, is that the son is the one that chased him at first. Rick Cho is following behind. So the way that the prosecution had kind of laid out their claim is that Rick Cho was the guy chasing him, right? And he's armed and he has the gun. And like, from all I can tell from what they're saying, or assume at least, is that it's out and like visible. And the defense is like, nah, the son was the person that was pursuing at first. Rick Cho's following. Bro doesn't even know that he even has a firearm because it's holstered, or I mean, he could maybe assume, but it's not like out and like pointed. So like that's where I was like really like, yeah, like I agree. I think he's hyperbolic and he keeps harping on the gun, and that's giving me red flaggies. But by the same token, he's laying out something that's rather reasonable for most people to look at and just be like, okay, well, man, he pointed the gun at him. Like, what's he gonna do? Like he's protecting his son. So yeah.
Well, and at the end of the day, a trial is about who tells the better story. And
True.
and at this point, the defense is telling a better story, but I'm going to be very anxious to see if the evidence matches up.
Yeah, that's what I'm waiting, because like we're getting the stories right now, but we're gonna get into the facts here in a little bit. So yeah, okay, let's finish up this old man's story weaving, and then we will get into some of the facts of the case.
At the hands of somebody who had a gun pointed at him, that was a reasonable belief, and he fired his weapon under the law in defense of his son. As I submit to you, anybody in this courtroom. Now you will hear a testimony that's consistent with that. I'm telling you right now, it's consistent with what has been said in this case by the witnesses. And you will hear testimony from various people that you will find is consistent with that version of what I just told you is consistent. There's no question that gun belonged to this young man. There's no question that young man had that laser on that gun. As a matter of fact, you will see evidence. We submit that we'll be able to lay a foundation in our defense that he was on social media.
Oh my God, this is going to drive me crazy. Walk me through this real quick. I know I asked you this in the comments, but I'm going to need you to repeat this for the audience. Okay, he's talking about a laser on the gun. I'm assuming it's an attachable sight, right? Correct? Is maybe what he's talking about?
Yeah, it's a laser that, depending on the type of laser, when you grip the handgun or you press a switch to activate it, it has a laser beam that roughly is where the bullet would land if fired. So this laser better be relevant, because otherwise it's just pure hyperbolic. It doesn't make the gun deadlier to have a laser on it. It arguably can increase your hits, but there's plenty of evidence to show that's not the case. But this laser better be relevant at some point.
Yeah, I don't know. He just keeps saying laser, and I'm like, it's just feeling a little crazy. So let's see if it comes up. Let's see if it becomes relevant here in a second, because he's mentioned it about 30 fucking times.
Here, the night before, wearing the same clothes, holding the same gun with a laser. There's no question about it. You'll be satisfied at the end of this case.
Sharks with laser beams attached to their freaking heads.
Where everybody was placed in direction where Mr. Chow was when he fired the weapon. where the son was, and where Mr. Carmike Belton was. All of that, I submit to you, will be consistent. Mr. Chow did not take any joy in what happened. It was chaos. Adrenaline's pumping. Can you imagine what you're thinking about when you had to go ahead and take that action to go ahead and, first of all, see your son with a gun being pointed out by a 14-year-old, and then having to fire the weapon to protect your son? What was going through his mind, what was going through his heart, what was going through his head, wasn't something he did because he wanted to. He did it because he was trying to protect his son. But the state doesn't talk about the gun. The state doesn't offer any explanation or rationalization as to why that young man pulled that gun and was walking around with that gun in the streets of Columbia, South Carolina. Mr. Chow
Who cares?
didn't just run away at that point. He rendered aid. He stayed right there at the scene. He started doing chest compressions. You'll hear that. The young man was regurgitating. Terrible things, terrible scene. Mr. Chow was bending down, cleaning his mouth out, and giving him mouth-to-mouth resuscitation. You'll hear that. This is the man who acted with malice. This is the man who acted with criminal intent. I submit to you not.
Hold on. I gotta say, if that's true, that, like, if I were sitting on that jury, that does change my perspective a little bit. Like, he's rendering aid, he's rendering care. Like, I'm not saying it's like the best fact in the world, but I'm also saying that that's something I'm looking at and I'm being like, if I'm determining malice, intent, and other things like that, like you would in a murder charge, I would say that that's relevant to me. I don't know how you feel about it, Law, but that is relevant to me, that he stops, he renders aid, he gives care, he, does the best he can. I don't know. What are your thoughts?
Yeah, I'm gonna have to look at since we're playing the 13th juror, I'll probably have to try to pull the jury instructions to see what the instructions were for the charge. But that might be a reason for the acquittal. If they were going with a malice murder, and which sometimes is first degree, sometimes is second degree, depending on the state. Instead of something like a negligent homicide, the overcharging might be the issue here, because in like a murder 2, you don't have to have malice, but you have to have intent to do the thing that causes the harm, i.e. point a gun and pull the trigger. That's all that the state would have to prove for like in Minnesota, that would be like a murder 2. You didn't have malice, you didn't have premeditation, you didn't have a plan to do this, but you did intend the harmful act, the pulling of the trigger, which you knew or reasonably should have known would have caused death or great bodily harm. So if they overcharged it and the state chose to put the burden on themselves to prove that there was malice here, that makes it a harder case to try. Now, sometimes this happens. I saw some comments in higher profile cases because the public really wouldn't accept anything less.
So that's been a at least, it's TikTok streets and news medias. Like, I haven't looked at jury instructions, so I'm just speaking to something I've heard a chronic complain about, that there wasn't lessers on this, like no manslaughter, anything like that, like no lesser charges. And they brought it up a few times that this includes some form of malice, malintent, like he's intentionally out here doing this. So if you can pull the jury instructions, that would be great, because I'm just saying that would be a factor for me. Like, if I'm having to determine some sort of intent here, and this man is, he's saying, he had pointed a gun at my son. I took this protective step to save another, but also when this person went down, I rendered aid, et cetera, et cetera. That would be something I would be weighing if I'm weighing intent. Now, again, if it wasn't on my jury instructions, that's a little bit different, but I guess just overall, that would be something that would be in the back of my mind. So
Interestingly, it tells a good story, but it's not legally relevant because what happens after the shooting doesn't erase any malice or culpability from before the shooting.
No,
Yeah, no, and I get what you're saying. Like the legal
yeah.
standard, but as a juror, you're looking at that and say, oh well, dang, he must not have had malice if he tried to save his life. It's good shell game by the defense attorney here to try to get the jurors emotionally connected to something that's not legally relevant.
Yeah, like while it may not be something that like I'm basing my entire decision on, it's still something that's in the back of your mind when you're sort of considering that reasonableness level to it. I'm not saying that it's the whole factor you consider, but I'm saying it does put it in the back of your mind, and it is kind of like, oh, well, like maybe this just wasn't like it shifts the tone of the story. Maybe not the legal standard, but it does shift sort of that tone of the story. Okay, we get back into this. Hopefully Grandpa Time will finish soon.
This is a man who was deeply upset about what happened, to the point that he was doing some things that I wonder how many people would have been doing exactly what he's doing to try and save this young man. And then other people came over. But Rick Chow stayed there, did chest compressions, took vomit out of his mouth, with his own mouth, so the young man could keep breathing. And then other people, more qualified people, were able to go ahead and try and help the young man. Unfortunately, he died. Unfortunately. Mr. Chow stayed around, stayed at the scene. He was there when the police came, told the police what happened, gave a brief description. It was not an interrogation, it was not an interview, it was not a complete, what I would call an interview by law enforcement. But there were snapshots taken of different people, Andy Chow, Rick Chow, some of the people who were at or around the area there. He stayed there that entire time, went back up to the store, and when the police came up to the store, he showed the police the videos that they had. He was cooperating 100%, doing everything he could to not only save the young man's life, but also to cooperate with the police. Everything he could. His wife was doing the same thing. His son was doing the same thing. These were not people who had any kind of joy in what had happened. They were upset. It's terrible. Not as bad as, obviously, the parents of this young man. Not nearly to that level. But having shot somebody and having someone die, it's got to be something that's just so difficult to go through. When he agreed, they gave over all the videotapes to the law enforcement as well that were in the store. They all agreed to go down for further interviews at the sheriff's department over the course of the next few days to give a real interview as to what happened bit by bit, word by word. But within 15 hours, before any of the investigation really had focused with detailed interviews, with forensics things from the labs as to whatever, ballistics, DNA, whatever the issues were, within 15 hours, when Mr. Chow was called down, he was told to report to the sheriff's department and be placed under arrest for murder. That's how long it took, 15 hours. Ladies and gentlemen, I again say this to you. The state wants to frame this as a situation where a young man may have taken some small item from a convenience store, wrongly accused, chased, not that he wasn't chased, he was followed, chased and shot down because he had taken something from that convenience store. I submit to you it's not that simple. You can't frame it like the state wants to frame it. Andy Chow had a reasonable belief that something took place in the store. He followed the young man out. Rick Chow had a reasonable reason to go ahead and follow his son to see what was going on to protect his son. Andy, when he saw the pistol...
That's so weird.
Pulled, as the solicitor pointed out, 130 yards down the road. He started backing off with his hands up, and his father saw that pistol being pointed.
I want to clarify why I find this weird. I don't find it weird that a father would want to protect their son. That's not what I find weird. I find weird that if son is arguably following him out of the store just to see which way he's going, why would he be in pursuit of this person, right? Like, watching him to see where he's going, very reasonable. You know, just kind of poke your head out. Oh, he took a left and it kind of looked like he went down that street. Okay, sure. But like, I don't know, something feels weird about that to me. It just like the whole he's running and then, but why? But why
Well,
though?
we'll see the video, and the son, his face is pissed, and he starts booking at full speed. He's going to fucking tackle the kid. You know, like that's what's going on. He's not just, you know, observing and reporting. He had a cell phone and he didn't dial 911. He's not calling in instructions to the police to say, okay, he's turning left on this road, he's turning right on this road. He was chasing after the kid. So yeah, that's, we're going to see the videos, but you know, I've seen it. I've seen them already. So
Damn it,
again,
Law. I'm just
yeah,
messing with you.
no, we'll see it. I would be expelled from this jury anyway because I've already know too much about the case. But yeah, the whole this whole notion. I'm very curious to hear what the witnesses have to say. I did look at the jury instructions though, and so South Carolina doesn't have first degree, second degree. It's very much like Texas, where murder is
Okay.
murder, and then the sentencing is, you know, determined on the particular factors. And so here's murder is defined as malice aforethought, characterizing malice as ill will, hostility, or the intentional commission of a wrongful act without just cause. So that would count for, you know, pointing a firearm at somebody who, you know, didn't pose any threat. But interestingly, too, is the defense waived any lesser included charges. So it was an all or nothing verdict. It was either murder, and they waived any voluntary or involuntary manslaughter.
Why would they do that? Because they didn't think they could kick him on a
They thought that
murder?
the state, well, they thought that so both the defense waived it because they thought that they wanted to have the state prove the more difficult charge, and I from what I'm reading, there's nothing that would have stopped South Carolina from charging both murder and voluntary manslaughter and giving the jury the option of which one to choose. And then the defense also has the ability to provide a verdict for a lesser included charge, and they waived that. They must have been confident, or, you know, just wanted the state to have to prove the harder case. So that's interesting to me.
Let me ask you this. I know like certain like, you know, double jeopardy and shit comes up, but like could they go down and charge him with the lesser included offense now since it wasn't included in the first go?
No, he's already been to trial on the
Okay.
act. You
Just want to make
don't get a
sure.
second bite at the apple. Yeah.
Okay. All right. I was trying to think maybe they had some sort of fucking strategy here, but you know, apparently not. All right.
At his son with and by the 14-year-old.
God, he's on 1.25. Hurry up.
He had to make a split-second decision to go ahead and defend or not defend, fire or not fire, to protect his son, his pistol. What should he have done? Because that's what the state is trying to get doing Monday morning quarterbacking. That's what it's all about now.
You just call the state Monday morning quarterback.
I submit to you, and I'm going to sit down in a moment, and I appreciate you listening. There are 3 questions in this case. One of them is no particular order. But what was the 14-year-old doing walking around Columbia with a semi-automatic 9mm weapon in his fact, look bad, or, I mean, I'm sorry, in his hoodie, with a bullet in the chamber, illegally possessing that weapon, illegally walking into a store that barred people coming in with weapons. Another question is, would any reasonable person believe that their son was in imminent danger of death or serious bodily harm such that they had to exercise the right of self-defense? And what would any reasonable person, the third question, what would any reasonable person do under the same circumstances? Fire or not fire? That's something that everybody's going to have to think about. Mr. Chow told him to drop the gun, he didn't. Mr. Chow had the gun in his holster, he didn't pull it out until he saw it, or his son said he's got a weapon. Again, he made that split-second decision. There was no malice. It doesn't even fit the definition of what murder is in South Carolina. With malice, protecting your son. No criminal intent. Fired one shot, stayed there, tried to render aid, life-saving aid, and cooperated with law enforcement. Stayed on the scene. Agreed to further interviews. Then was arrested within 15 hours. Quick decision. I'm going to sit down now, and I do appreciate you listening to me. I submit to you there's one scenario more frightening than a man walking around the streets of Columbia with a pistol, semi-automatic pistol, one in the chamber.
Say semi-automatic one more fucking time.
On his gun. There's one scenario more dangerous than that, more frightening than that. He's a 14-year-old walking around town with a semi-automatic pistol, loaded, chambered, with a laser on his gun.
Laser.
How frightening is that? A 14-year-old.
Listen, Law, sharks with laser beams attached to their freaking heads, okay?
Of making good decisions, sound judgment decisions. That is more frightening than anybody in that same situation. And that's what Rick Chow and Andy Chow were faced with that day. I challenge the state at this time to offer some justification or rationalization as to why this young man illegally possessed a semi-automatic pistol with a laser.
It doesn't fucking matter.
Whether the motive knew it or not, that is
That's what's giving me red flaggies about all of
But
this.
why? You're entitled to know why.
No, you
At
aren't.
the end of the case, we hope that you will find that they have not met their burden of proof in proving guilt beyond a reasonable doubt for the evidence or the lack of evidence, and that they have not disproved beyond a reasonable doubt that Rick Chow acted to defend his son's life, and it was reasonable because it was an imminent danger to his son of death or serious bodily harm, or he reasonably believed that. Thank you.
Thank you, Mr. Rowe. All right, ladies and gentlemen, we've been going just over an hour, and we told the first witness maybe rather lengthy, so I'm going to take our morning break right now, give everybody about 15 minutes to rest themselves, stretch their legs. Also have to begin the process of sequestering the witnesses.
Sorry, I was just moving it ahead. Any thoughts right now, Law? We've heard both the openings. I don't know if you got anything.
Nothing additional other than don't tell the jury you're going to sit down and then talk for 5 more minutes.
Well, he's like 950, so maybe he forgot he said it. I don't know. It just like I was shocked. Like honestly, when he stepped up, it was just not what I was expecting on the defense side. But you know, more power to him, I guess. All right, I guess we're about to get into witnesses. We'll do maybe about 45 more minutes, and then I'm gonna get off here. Or we'll get through whatever we gotta, first witness, I guess. And we'll come back to this tomorrow.
I don't know if it's just me, but I'm frozen on old guy on the YouTube screen.
Oh, let me refresh it real quick. Give me one sec. Hold on. Sorry, this is just being a asshole, so give me one sec. Add source, window. Add. Try again. Add source. What the hell? Okay. Chrome. Sorry, TikTok I'm terrible at using TikTok Studio, so I apologize, guys. Give me just a minute. Oh my god, did it have to make it like a norm? Okay, I think we're here now. All right, we got it. Oh. There we go. Or can everybody see it?
Looks good here.
Jesus, sorry. Sorry, I'm trying to get to it. Give me just a minute. It's kind of a pain in the ass. It looks like he's about to take the stand.
Do you swear or affirm the testimony you give in this case to the truth and whole truth and nothing but the truth so help you God? Yes. Take and set seat in the witness stand and state your full name for the record.
Okay, Mr. English, where are you employed right now?
The Great Falls Police Department.
Okay. Was it Chester County?
It is Chester County, yes, sir.
Back in 2023, where were you employed?
Virgin County Sheriff's Department.
Okay. And what were you, a deputy, road deputy back then?
I was on patrol, yes, sir.
Okay. Do you recall the night of May, or the late afternoon of May 28, 2023?
I do. I was working on shift that night.
Okay. What were you up to around 8 o'clock?
We were dealing with a few individuals who broke into an apartment off of Ranch Road, and then I was dispatched to 7441 Parkland Road.
Okay. So you're dealing with, what'd you say, a break-in of some sort on one part of town, and then you said you're dispatched to 7441 Parkland.
Yes, sir.
Okay. And what was that in reference to?
The Parkland call?
Yes, sir.
In reference to a shooting hit, so someone got shot.
Okay, what is that 7441 Parkland Road?
That is the Shell gas station.
Okay, and is that Richland County?
It is, sir.
Okay, is that where you initially responded?
I did, yes, sir.
Okay. Let me ask you, sort of generally, to orient the jury. That location, that Shell gas station, 7441 Park Lane, it sort of sits at the corner of two roads. Is that right?
Yes, sir.
Okay, obviously Park Lane Road.
Yes, sir.
And then what is the road that cuts up beside it?
The secondary road is Spring Tree Drive.
Okay. And Spring Tree Drive, does that dead end at some point?
It does. It goes into an apartment complex called Willow Oak, if I'm not mistaken.
Okay. Let me show you a number of pictures that sort of show that area. This is states 14 through 31. Tell me if you just generally kind of recognize what these are.
You want me to look at all of them?
Just look through them and I'll ask you a question after you review them.
Okay.
It's a lot of fucking pictures.
Okay.
Cass, if you hit the right arrow on your keypad, it should jump forward like 5 seconds at a time.
7441 Parkland and then Spring Tree Drive.
Okay, thank
Yes, sir.
you.
Okay, Spring Tree, you talked about it dead ending at some point. There needs some parts there. How would you describe Spring Tree Road?
It's a road that goes to a dead end. There's 3 apartment complexes. We have 220, 250, and then 100 Willow Oak Drive.
Okay, is it a hilly road? Is it a wide road? Is it a narrow road? Is it a flat road?
It's pretty flat.
Okay, is it a curvy road? Is it a straight road?
This is a straight road, like a straight shot.
Okay.
This better be
Now,
fucking
you said,
relevant.
the call for service had you going to 7441 Park Lane Road, which is that Shell gas station. Were you directed elsewhere after you arrived on scene?
Yeah, so when I arrived on scene and stepped out my patrol vehicle, I was flagged down to go slightly further down towards 220 Spring Tree Drive.
Okay. So you go to the Shell gas station, and then later you're rerouted up farther up the road.
Yes, sir.
On Spring Tree. And then you went immediately to where you were directed to go.
Yes, sir.
And what did you observe once you got there?
I observed Burwell Mike, or a black guy, laying on the ground with a bystander doing chest compressions on the individual, and multiple witnesses just standing by.
Okay. Did you later learn who the black guy was who was on the ground?
Later. Yes, sir, I did.
At the time, did you understand him to be the victim of the shooting that you were responding to?
Yes, sir.
Okay. And you said he was, medical aid was being rendered on him when you arrived, is that correct?
Yes, sir. That's correct.
Okay. And so what did you undertake to do once you arrived on scene?
I just told the individual continue to do chest compressions due to EMS being like 10 seconds away.
Okay. Were you first responder?
I was first deputy on scene.
All right. No, it's kind of state does all they're identified. It's going to be states.
Give me 2 seconds. I gotta get some lotion. I'll be right back.
The objection. All right, I think it is states 14 through 31 without objection.
Okay. And permission to go ahead and start publishing.
Yes, sir.
I just want to orient the jury. Do you mind just kind of explaining some of these things if I put them on the screen?
Yes, sir.
Okay. Stephanie, can you hand out states 15? Okay, Deputy English, do you see states 15 there?
I do.
All right, if we're looking at states 15, we're looking at the right side of this photograph. What road is that we're looking at?
Like the one that goes up and down, correct? All right, that's going to be Park Lane.
All right, and that red roof structure is what?
That's going to be Shell gas station.
Okay, the road that cuts between from Park Lane and then goes to the left of the picture.
Are they trying to show how far he was chased?
Okay, and that's what you were describing.
Yeah, trying to just give a visual layout to the jury of
and these are the apartments we
the
see
scene.
the roofs of. If you
Gotcha.
if we're looking at Stage 15 and we're looking from right to left, on the left side, you see some swimming pools and whatnot. Those are the apartment complexes you're talking about?
Yes, sir. That'd be 220 Springtree, and then a little further down would be 250 Springtree.
Okay. And so your testimony is you arrive at 744 on Park Lane and you're directed farther down Spring Street.
Yes, sir.
So you talk about this being Park Lane, that being the Shell gas station.
Yes, sir.
Where you arrive, and then you're directed down this way, down Spring Street?
Yes, sir.
Okay. And did you see generally where you found the victim of the gunshot wound in this picture?
Yes, sir. So if you look where the little wooded area is, so bring your little stick, yeah, about right in that area right there.
Okay. And that's where you were talking about seeing, you call him the black guy. Do you know him now to be Cyrus Carmack Belton?
I do.
Okay. And he was lying on the ground. You said people were rendering aid to him.
One bystander, yes, sir.
Okay. Did you also see the defendant, Mr. Chow, at the scene at that time?
I did.
Did you understand who he was when you first arrived?
Not at all.
Okay. What were you doing? I mean, were you securing the scene? Were you collecting evidence? What exactly were you doing?
So one was trying to secure the scene. I was informed that there was a weapon on the ground, so I wanted to secure that in the back of my patrol vehicle, while also setting up crime scene tape and let EMS do what EMS does.
Okay. When you left the 7441 Park Lane to go to where the victim was, did you walk up the street or did you drive your car up the street?
I drove my patrol vehicle.
Okay. How would you describe the distance between that Shell station to where the victim's found on the ground?
I'll say about 130 yards.
Okay. I mean, would you describe that distance as being significant in any way, or
Yeah.
why do you walk from the gas station up to the?
It seemed pretty far.
Was there an objection?
Remember me showing you?
Didn't say that there
drone
was.
footage that sort of shows a video going from the gas station up the street to where the victim was.
Yes, sir, I do.
And did that fairly and accurately depict what you yourself witnessed whenever you drove from the gas station up to where Mr. Belton's found?
Yes, sir.
This is states number 2. You recognize that in the drone video?
I do.
Now, the state does offer states number 2 for admission of evidence. Any objection? Come on, hang on.
I think the sound's being weird. Maybe?
Subject to conversation, no objection.
All right, be admitted as states exhibit 2.
Okay. Any permission to publish?
I think they might be muting it during objections.
All right. Before you
Interesting.
start, Stephanie. All right, what are we looking at right here? Just and I hate to keep belaboring the point, but I want to orient everyone with what we're looking at. Here.
I think the first objection was speculation, and then
Yeah.
that one was
This
leading.
first shot, states number 2. We're looking to the left. First of all,
Sorry, let me pause real quick. What did you say the second one was?
Leading, I think he was giving him the answer to the question in the question.
Yeah. The would you say it's pretty far, that one?
Yeah, you're not saying like how would you characterize the distance,
Yeah.
and then, if you're saying yes or no question, it's most likely leading.
I gotcha. Okay. That's interesting. All right. What? Oh, okay. Well, we got
Also, kind of like a. Oh, sorry.
No. Go ahead.
I was just saying it's also like a ticky tack objection. Like it's. For example, the trials that I had last week, I could have objected 25 times, but like I probably only objected 2 or 3 where I thought the prosecutor was kind of egregiously trying to get the officer to say something specific. When you start doing really pedantic objections, the jury starts getting pissed at you.
Yeah, I could see that. Like, you kind of weigh out the necessity of them, I guess I'm trying to think of how to say that, but yeah, like just kind of unnecessary stuff.
Yeah, well, it's like if I know that the prosecutor can get the same answer by just restating the question a different way, I'm not going to go through the whole song and dance. But if I think the prosecutor's trying to get the cop or the witness to say something very specific that the cop isn't saying, then I'll object, because you got to ask better questions. You can't give them the answer that you want them to say.
I gotcha. Okay, well that's interesting. Okay, let's see what this is. Apparently it's a picture of a gas station.
Now, Deputy English, if we're looking back this way, that would be Park Lane, right?
Correct.
Okay. And in this road right here, we see a couple cars on the side. That would be Springtree.
That is correct.
And of course, Shell gas station sits on the corner, Park and Springtree, which you are testifying.
Yes, sir.
Do you recognize this as the front entrance to the gas station?
I do.
Okay. All right. Give me play. Okay. Press play.
Sorry, I can't predict whenever they're gonna just pause. Oh, god damn it. Sorry, they were playing a video and nobody could see it. Hold on. God damn it. I swear to fucking God, YouTube. Jesus Christ. Sorry, I'm trying to get to exactly where we were. Okay. Because of course it's going to do this shit right now. Sorry, sometimes it doesn't like to cooperate with me, so I'm working on it. Motherfucker. Google Chrome. I don't need a chat replay. Fuck off. Okay, here we go. My God, guys. This is right after the gas station picture.
And the end on that video, is that essentially where you found Mr. Carmack Belton?
That is.
May 28, 2023?
Yes, sir, that is.
Okay, and that accurately depicts the pathway you would take to get there from the gas station?
Yes, sir.
All right. You talked about seeing Mr. Belton and aid was being rendered. Do you remember the fire department showing up?
I do. I remember EMS and fire department showing up.
Okay. You remember EMS showing up? Do you remember eventually Mr. Belton being taken away in the ambulance?
I do.
Okay. At this point, he's being taken care of. Does your focus shift to crime scene integrity?
It does.
And so did you put out crime tape and whatnot?
I did. I put out crime scene tape.
And a crowd started to gather at that point, or were there people on scene other than Mr. Chow and Mr. Belton?
There was just bystanders, some who heard it, some who witnessed it.
Okay. And did you at some point
Okay,
try to
so
speak
there
with
may
some
have
of
been
them?
witnesses.
I did.
Okay. At some point while you're out there, did you begin locating evidence?
I did.
Okay. You remember a backpack?
I do. A black backpack.
Okay. And where was that?
Like in oh, you can't see it from the picture,
We'll go back to the number 2. Let me see if we can.
but it was located in a drainage ditch.
And I'm gonna get to it in a minute, but you're yeah.
So
you
that's
see,
the
this is
ravine
what
that the
was-
defense
this is
said it was
case
tossed off
number
of?
26 that's been admitted.
Yes, I was about to say, I believe they alleged that he tossed it, but the prosecution said it kind of just like was, fell or lost, like they didn't specify that he tossed it. So,
Well, yeah. So I'm when the defense said he threw it into a ravine, I'm thinking like Back to the Future, Clayton Ravine. That the train goes over. This was a
absolutely.
drainage ditch. Come on.
I mean, well, I guess people have different words for different things. But yeah, I mean, I honestly didn't know why the defense or the prosecution brought that up because who fucking cares? Like the backpack is relatively irrelevant here. Tossed it, it fell. I don't know what it matters to why he got, shot. Like I just couldn't figure it out. Maybe it's important later. For me it was like, what the fuck? Okay, let's see if this works again.
Yeah.
Is it playing? Okay.
So you can see.
Sorry, this thing has been crap.
All right. Do you recognize these 2 poles right here?
I do.
Okay. And do you recognize this stand of Bradford pick, these trees right here?
I do.
Okay. And would you agree that where I'm pointing this pointer is essentially where Mr. Belt was found?
That is correct. Yes, sir.
Okay. And the drainage that you're talking, or the drainage, I guess, how do you describe it?
I call it drainage ditch.
Okay. Is that what you're talking about right here?
I am.
Say again?
Yes, sir.
Okay. And what did you
the
say
fuck?
you found during that drainage ditch?
Black backpack.
Okay. And did you come to understand who that belonged to?
At the time, we didn't, but we later found out who it became.
Mr. Belton?
Yes, sir.
Or was associated with him somehow?
Yes, sir.
I mean, you collected?
I did.
Okay. What else in this general area that we're looking at, station number 26, did you locate?
A shell casing,
Okay.
and then a tactical light.
Okay.
A laser.
Were you wearing a body-worn camera at the time?
I was.
Okay. All right, so you saw a tack light. What is that?
It's a attachment that you can put on a firearm.
Okay.
Like a pistol.
And it was something you would, manually put on a pistol?
That is correct.
Are these common or uncommon?
Pretty common for people who shoot, I guess, towards the nighttime.
Okay. And what do? They provide like a flashlight. Some have like a laser to help with accuracy,
Yes, sir.
help with vision. Do you own pistols with tack lights?
Me personally?
Yeah. Or have you ever been issued one, or have you ever?
At the sheriff's
operated
department. Yes, sir.
Okay. And you said they are not uncommon.
That's not uncommon.
All right. What else
Duh.
did you find? You got the backpack. You got a tack light. And the tack light was attached to a gun or not attached to a
It
gun?
wasn't attached to the gun.
Okay. And it was just lying somewhere in this vicinity here?
Yes, sir. It was located.
this why this is
near
relevant?
The shell casing.
Okay.
I also located.
And so you found a tack light and you found a shell casing?
Yes, sir.
Okay. And did you mark those anyway?
I did.
You said, started to ask you at least, you had a body-worn camera at the time?
Yes, sir.
And it was operational?
It was.
Okay. Let me show you states number 1, see if you recognize this.
I do.
Okay. And does it, now with the exception of the court, the state, and defense has muted portions of it.
Okay.
And you watched that earlier today?
I did.
And aside from that, the agreement by everybody that portions would be muted, does it fairly and accurately represent what you yourself witnessed?
Yes, sir.
May 28, 2023?
Yes, sir.
The subject of yesterday's ruling is objection to states number 1. And we've also been given states 32 through 43. No objection.
32 through 43.
Yes, Your Honor, 32 through 43, which are stills from state 1. Can you move that up there? I'm sorry.
All right. United States at this time offers states number 1 for admission to evidence, permission to publish.
Subject to yesterday's pretrial motion, and it'll be admitted as stage 1 without objection.
Hey, where's he at? Hey, EMS is right here. Okay, keep doing compressions. Keep doing compressions. Okay. Still doing compressions. Okay, yes sir, I see that. Okay. Keep doing compressions now, the EMS is right there. Hey, y'all stand back. Stand back.
Okay, so I believe they're playing body cam footage back to him. I was gonna ask Law about this. Like, he's the first person to arrive on the scene. What would basically he be tasked with doing, particularly at a scene like this? There's somebody who is on the ground bleeding out. I'm sure there's multiple people involved. Like, what would he sort of be doing at this point? Or I don't know, Law has bars, so Law, are you here, Pookie?
I am sorry.
Oh, no, I was asking about, like, he's the first person to arrive on the scene. He said there were multiple witnesses. There's a person bleeding out that he's given, instructions to keep working on. Like, what would he be doing at this time? Because they're not showing us his body cam, so I'm just trying to figure out, like, what sort of activities would he be doing? Is he trying to get people out of the way? Is he trying to clear the way for EMS? Like, what would his priorities be?
Probably securing the scene because EMS won't arrive on a scene unless it's secure. But also, I think they're trying to just paint the picture for the jury. But yeah, the first thing he has to do is secure the scene, make sure there's no additional threats, and then it's the life-saving efforts.
Gotcha. Okay. I just wanted to make sure. Thank you.
I'm gonna need your information since you were doing compressions. How long were you doing compressions for? 30 minutes? Alright, cool. Hey, just don't cross it. Okay? Thank you.
Free to walk through.
Yeah, 59 is in the back of my trunk. You hear me? 59 is placed right here is in the back of my trunk. I go down there, Sarge. I got it. You see it? I got it.
This is where we find the backpack.
Let's hang up on the check off. No. I need you. You got the ID or anything? You want to go get that for me?
Looks like quite a few people are there, multiple witnesses. And this looks like it's in the middle of fucking nowhere.
Are you the one who shot him? Where's your ID at? Hey, Sarge, I got a store clerk right here. Alright, come back to my vehicle. Come on. Hey, right now, he's talking to me. He's not talking to y'all. It's at the back of my car. Stay right there, okay? Stay right here, stay right here. Stay right here.
I was just driving by home, and then I seen him over here with them, and I was like, oh, he looks unresponsive, so I came up with like something.
Okay, all right. I need y'all to get in the street this way. I need something else to tie to. I'm trying to do this, but I need something else right here. What's that? Dang, that's a flashlight. Sorry, that's the flashlight coming with it.
Okay. That's where you were noticing the tack light right there, you're pointing to it?
Yes, sir.
Okay, and then did you do anything?
No,
to
guys,
mark it at
it's
the
not
time?
being muted on
did,
purpose or anything. It's because,
I want to say like a card.
hold on.
I'm not stopping again, but after that, is that?
TikTok Studio has compatibility issues, so when you're watching this stuff, sometimes it'll just freeze up, and it gets pissy with me, so I have to basically reset the video. I have a really good internet connection. It's nothing to do with that. It's just being a dick.
About whenever you find the shell casing and you point it out and mark that as well?
Yeah. Yes, sir.
Do you know any, sir? Sir, stay right there. Stop moving. Stay right there. Stay right there. You guys are, come on. Keep going. Keep going. Keep going. Keep going. Keep going. Keep going. Come on. Come on. Come on. Come on. Right there. And I promise you, okay, we'll get to you, okay? Thank you. Sorry, I need your voice. Do not cross this tape. If you cross this tape, sorry, don't pick up anything off the ground either. If you cross it or pick up anything off the ground,
Okay, so here's what we're gonna do, guys. It looks like he's gonna be on the stand for like another hour and a half or so. So what we're gonna do tonight is we're gonna finish up with what they're showing from his body cam. Tomorrow night, I'll mark down the time that we stopped at. We're going to come back in and continue. We're playing 13th Juror on the Rick Chow case. Law may or may not be here. He's a busy man. I'll try to have somebody here for commentary. But we're just going to try to look at this from the perspective of the jury. This is from Court TV. I do try to speed it up or fast forward through parts that are just ridiculous. But we're going to try to look at what they looked at and see how they arrived at the point that they did We'll finish up with his body cam. We're going to come back tomorrow at about 10 o'clock. I try to start about 10, and then we'll get back into this more. 10 p.m. Central Standard Time, Kathleen. I usually put it up in my story too that I'll be having it. We'll start about 10 o'clock. And then what we'll do is we'll come back in after the body cam. If Law can be here, I'm sure he will be. But if not, he's got shit in life and stuff to do. So we understand. But we're just going to be trying to look at it. You just missed the opening and then we're in the first witness. So really, no, you haven't missed much at all. Court TV has all 3 days of this trial. So it's going to take a while to get through. We'll try to figure out the best way to do that. But we'll watch the whole thing. But we'll get through the rest of this body cam and then we'll sign off and then we'll get back into the rest of his testimony tomorrow, if that sounds good for everybody. Oh, fuck me. God damn it, Google Chrome. I hate you, you dirty bastard. Hold on.
He went down there to do something and he came back. I didn't know he was suffering from a lifetime. I'm just he's been there. We had a attack laser and we do an attack right here and then showcasing what's it 45. The monster actually. That's a cat, But it is weird because that's the one we did compressions. That's her who did that. Apparently this is getting their information. Did you ever get your information to the deputy? Your ID? Okay. Thank you. Which is weird because the rounds that's in there doesn't match what 45 you want to look at it.
Oh, I was muted. Fuck. Never mind.
That's what I got. I think that's just my technique. Yeah, sure. Looks like 45. I don't think the backpack has anything at all.
I was saying that I find it odd that the tack light that he found, which is brought up 8,000 times by defense guy, and then the shell casing were like right next to each other. It either bolsters maybe the claim that there was a gun pointed at somebody, or it's just weird business. I don't know. It's giving me a vibe, but we'll keep on it.
shoplifted in my store. Okay. I said, no, I followed him up. I followed him.
Hold on. He just said he shot me in my store.
Did you say shot me or shoplifted in my store?
Hold on, let me see if I can just replay that real quick.
Just hit the left
Yeah.
arrow. It should go back 5 seconds.
Okay, let's see if this helps. Okay.
He shoplifted in my store.
Oh, okay, yeah, shoplifted. Okay, I was like, wait, hold on. Did he say he shot me in my store? I was like, holy shit, this is a different story. Okay, thanks, Law.
I followed him up. I followed him. On the way down here, we told him to drop it in the store. I think it's a train something. I think he probably did. He checked the
I hate you, TikTok. I fucking hate you. Goddamn TikTok
You
studio
can just, I think you
bullshit.
can just call it there for the night, Cass. We can
Yeah.
bookmark it.
Okay.
You said 45 minutes like an hour ago.
Yeah, that's true. I do my best, but I can't predict. So, okay, we'll come back to Rick Cho on the body cam and maybe me not wanting to kill TikTok Studio. But anyway, Law, thank you for coming as always. I appreciate you. If you want to be with us tomorrow, you're very welcome. If not, that's okay too. I know you got shit to do. But anyway, thank you everybody who came. I appreciate it. And we'll be playing 13th Juror on the Rick Cho case again tomorrow. We're going to try to get through all this and maybe figure out what fucking happened with the jury for them to be like, nah, Rick Cho's good. He did his thing. We're good with that. So, Law, any final words?
Yeah, I'm curious. There were witnesses, and if the defense's story is what it says, I just think the hardest mental thing for people to understand is it is possible to have two separate encounters. One is the attempt to pursue somebody who stole something, and two is an encounter that arose to self-defense. Now, that being said, I think going after somebody with a firearm because they stole a bottle of water is morally unreasonable by any common sense of morality or decency that we have. But that's not the question. The question is, when we're talking about an intentional unaliving here, and then a self-defense claim is when the self-defense was used, was it objectively reasonable? And we don't know that yet, but I do see some issues with the way the state has both charged and presented this case. That gives a little bit more clarity.
Yeah, like I can completely agree with on a moral level it's just ridiculous. Like I have no problem saying that. And I think some of the hardest things that people learn, particularly when they go down the legal avenue, is that justice and the law aren't always the same thing. Morality and the law definitely aren't always the same thing. It's a legal question, not a moral one. You can be perfectly entitled to feel disgusted, but it doesn't mean that the case was bad or that the jury did the wrong thing. It just means that that's what occurred. Now, there are times where juries do fuck off shit, and like it does happen, but if they followed the instructions that were given to them and did that to the best of their ability, that's all that we can really ask of them. But I agree with you, Law. Like just learning that justice and legality aren't always the same thing is kind of rough for everybody. But again, thank you for being here, Law. I very much appreciate you. Always love to have you. And I'll go ahead and get off of here so we can all have a good night. But thank you all again, and I will talk to you soon. Bye.
Thank you.
Bye, hun.